Hello, good afternoon. Thank you for joining us. I'm Brian Riley, Director of Business Development here in Southwest Florida for U.S. Legal Support. We have a very interesting and timely presentation for you today. We have Diana Bullard and Stuart Miles with Decision Quest. For over 25 years, Diana Bullard has worked with attorneys to develop persuasive visual communications in venues across the country. As a senior director, she has been involved in strategic design and development of graphic presentations for hundreds of cases brought to trial, arbitration, and other dispute resolution settings. Diana has worked extensively with expert witnesses, helping them communicate their message effectively to the intended audience. And Dr. Miles has spent the last 23 years consulting on over 600 cases in 24 states as a social scientist. With his specialized knowledge in personality and social psychology, he consults with trial teams on various social, cognitive, and technical issues related to trial preparation and case strategy. He has been actively involved in conducting jury deliberation groups, trial simulations, jury selection, witness preparation, and post-trial interviews for clients. Without further delay, I'll turn it over.
All right, well, thank you very much, Brian. I appreciate you organizing this on behalf of U.S. Legal. I'm going to show my screen now. And are we good, Diana?
Yes.
Excellent. I want to thank Lauren and the Lee County Bar Association for having myself and my esteemed colleague, Diana Bullard, do this presentation for you today. We know that we are in trying times, and we appreciate you taking the time to come and listen to us give this presentation. And we hope that you find something interesting and useful in your legal practice today. As I said, I'm with Decision Quest, which is a company under U.S. Legal, and we're a trial consulting company. We're a national trial consulting company, and we've been around for over 35 years, working with our clients. We have 8 offices across the country. We have 3 different divisions within Decision Quest. We have research, which is my wheelhouse. We have graphics and animations, which is Diana's wheelhouse. And then we have trial technology. And the trial technology group has actually expanded during the pandemic, because now, in addition to having courtroom technology, we're assisting clients with online trials, mediations, and arbitrations. We're doing this talk today to go over best practices for doing online jury research. And we started doing online jury research 6 years ago. We didn't start because we anticipated a planetary pandemic. We did it because we saw that there was a tipping point in technology, and we saw doing online jury research as the future of our field. And when we started, we did a lot of tests and validity checks, which I'll talk about. And so when this pandemic happened, for us, it was a seamless transition, going from our in-person research to the online research. And so what I want to talk to you about today are the best practices that we've developed over these 6 years, so that if you decide to do online jury research, you'll know what it is that you need to be looking for, and making sure that whether you're doing it yourself or you're doing it through a trial consulting company like Decision Quest, that you're doing it in a way that will get you the best outcome and also have the most security in line to make sure that the facts and information you're sharing during the research project doesn't get out into the greater public. When I started doing CLEs like this many years ago, they were much different than they are, and this one's going to be today. Because back then, I was spending a lot of time explaining to people, what it is trial consultants do. And that's really changed. I mean, we even have a network television show called Bull, which has a trial consultant. I know this is going to be a shocker, but my life is not nearly as exciting as his, but there are some similarities in what he does and what we do. And so we've reached the mainstream. So today's talk is going to be taking it that next step forward and talking about doing this online jury research and how it is that you can do that safely and effectively. Before I do that, I want to step back and just look at why do we do jury research to begin with, and how did this all get started? And about 40 years ago, attorneys were getting very frustrated in the process of doing trials. And so they approached social scientists like myself, and they said, please, can you help us? We're doing these cases, and then we're talking to these jurors after the case, and it's not making sense. What they're talking about, what they're hearing isn't jiving what's going on with the case. And so the scientists like myself used the tools they had at hand, and they developed research techniques. They started doing mock trials, and they started doing focus groups and community attitude surveys. And they really began to turn the tide in terms of helping these attorneys overcome these problems they were having. And the problems they were having were something that either you have or you've known somebody who's had it, or you've at least heard about. And it goes something like this. You get a case, and on the surface, that case looks really good for you. You've got a good venue, you've got a good judge, you like the facts that are coming through as you're going through the discovery process. You get to trial, and you do a great job. Or this person that you know of did a great job. They've got all their proof in. Their witnesses did well. They did good on their cross and direct examinations. Their closing went fantastic. They even maybe felt a little love from the jury as they were giving that closing. And then the jury goes out. And then they come back. And you or that person lost the case. And to make matters worse, you talk to the jurors and you find out that the things that were most important to them, the things that led to the decisions, the things that took all the oxygen up in the deliberation room, had nothing to do with the case that you put on or the other side put on. And then to your horror, you realize that had you known that, had you known what was really important to them, maybe even the day before trial, you could have fixed it. Now, we call those issues and facts that the jurors are leaning on that have nothing to do with what you thought the case was about, landmines. And every case we found has some kind of landmine. They can be huge ones, which bring the case down, or they can be smaller ones that maybe you can survive, but maybe they'll affect you on a portion. Maybe they'll affect the damages in the case. And that's what we do with our jury research. Obviously, we're looking to help you test themes and ideas. We're looking to help you fine tune your case, or we're helping find those landmines. And I'll give you a quick example of how you can do jury research, find those landmines, and mitigate them. Many years ago, I was working with an attorney that I'd done a lot of work with in the past. And he had come to believe, which is what I preach to everybody, which is, do something soon, do some focus groups soon in your case, because that can really help guide discovery. And so we were doing that in a case. And this was a case with a 35-year-old healthy young man who had a history of kidney stones. And so in this case, I was working for the plaintiff. Obviously, I work for plaintiff and defense. And so the plaintiff did a focus group. And what happened was this 35-year-old man goes to his urologist with kidney stones. And the urologist wants to do something called a retrograde pilot. And that's a study where they run dye up the ureter into the bladder and into the kidneys. And what they're looking for are the kidney stones. And if they find them, they can do some ultrasound, maybe break those up and help the kidney stone pass with less pain. And so this gentleman goes and he has this study done. And obviously to have this done, you're put under, he's asleep, he doesn't know what's going on. And the doctor shoots some films. The procedure's over. He comes back to see the doctor a day or two later. And he says, great news, we don't see any kidney stones. If you're having any trouble, come back and see me in a year. So being a 35-year-old guy and not having any problems, he doesn't go back and see the urologist. Well, a couple of years pass, and now he starts having troubles again. He goes back to see the same urologist. They do the same study. But this time the news is very sad. He has an 11-centimeter tumor sticking out of his kidney. And for this gentleman, it was a death sentence. And so what happened? What happened in this case? Well, what happened is that at this hospital, every time a doctor does any type of radiological study, it's overread by a radiologist. And the radiologist in this case looked at the films and he suspected a mass. And he wrote on the report, suspect a mass, do a follow-up study. Now at this hospital, there are 3 copies of that report. One goes into the hospital record for this patient. One gets sent with the actual film, and at this time it was film. And one gets sent back to the treating doctor who did the study. The treating doctor claims he never got it, didn't read it. The radiologist claimed, well, I did my part. I filled out the form. He should have gotten it. So for the plaintiff, this looked like a really good case. The radiologist, in this case, very unexpected finding, should have done more than just hope that a piece of paper made it to the urologist. The urologist knew he was supposed to get this report, and when he didn't get it, he didn't follow up. So we're doing the research, and things seem to be going well in some instances, but I noticed that the women in the group are very critical of it. And so doing my job, I asked them, ladies, why is it that you are a plaintiff? And they said to a person, when I go get a pap smear mammogram, if I don't hear back about the test results, I take personal responsibility for my health and I call the doctor's office. And I said, well, what is it that you would need to hear or know or see to not be so critical of the plaintiff? And they said again to a person, if that treating urologist said that this was nothing like a pap smear mammogram, that this patient had no reason to believe, that there was going to be a possible cancer diagnosis on this, then, that we would let that plaintiff off the hook. Well, because it was early and we hadn't done any discovery, we hadn't deposed the treating doctor. And so we asked those questions. And it turns out the doctor answered, yeah, nothing like a pap smear mammogram, no reason to suspect a cancer diagnosis. And he had to do that because if he said otherwise, then there was a higher duty for him to follow up on that report. And we're convinced that we did not lose that case because we did that research and we got that information. And so that's an example of how you can do the jury research, and find this information early and do something about it. So now what I want to do is real quickly talk about how jurors make decisions in the context of civil litigation and how that plays into doing our jury research. So how do jurors make up their minds and do this? What major psychological processes are going on or triggered during litigation? Well, clearly there's biases, and we know this. That's why we do voir dire. And so when we're doing the jury research, we're looking for what are the biases that are both helping and hurting my client's case. Can we overcome them? And more importantly, identifying them later on for assisting in jury selection. We're looking at the attitudes that are affecting the case when we're doing the jury research, both those that help and hurt us. And equally as importantly, we're looking at the strength of those attitudes. Are these long-held attitudes that people have? An example would be in the kidney cancer case, all the women in this case had an attitude around personal responsibility and following up on tests. These were very strongly held personal attitudes. They were not going to change those attitudes over the course of a trial. Now, there are other cases we do, let's say a patent case on a topic that the average person would never thought about or know about. So even if they have an attitude in the research, maybe this isn't a very strongly held attitude. Maybe this is an attitude over the course of a trial using certain techniques and arguments that you can overcome. So again, these are the things that we're looking for when we're doing the jury research. We look at attributions theory. In a lot of cases, we need to know jurors trying to decide who's at fault and how much are they at fault. And so we look at how these jurors are making these decisions. Why are they attributing liability? How are they deciding apportionment decisions? And this information is used in developing the case for trial. And then also we look at small group decision-making and dynamics, because we know that goes on at trial. And this is really important when we get to helping pick the jury, because we're assessing who are the leaders on the jury or possible leaders on the jury from the panel. We're assessing how strongly their attitudes are in favor of us or against us, and using that in our decision-making when we come up with our strike strategy. So how do jurors make decisions? And you guys have had this experience, and I like to use this as an example of how we filter information because of our attitudes, our experiences, and our preconceptions, and how that works out in the courtroom. So we're in the height of political season. There was a debate last night, and most of you have probably had this experience where you watch a debate and somebody you know watches the debate. It could be a close friend or family member, somebody you respect and you like, somebody you think is intelligent. And you both watch the same debate and you compare notes, and it's like you watch something completely different. You know, maybe something that was the most important thing to you, they claim never happened. Or if you can even agree on what happened, the significance of it or what it means is totally different between what you saw and what they saw. And that same thing happens in the courtroom. Jurors are given case information. They have their attitudes, their life experiences, and their preconceptions. And that affects what information they even notice and pay attention to, what information they actually take the time to store into memory, what information they retrieve from memory, what information they use from memory in making their decision. So in this case, we have all this case information, and we have a blue star and an orange circle and a red triangle. We have some other shapes that are gray. So that represents all the information that's available to our bearded friend here. So he's presented with that information. When he gets that information, he's really only interested and pays attention to the orange circles and the red triangles and the blue stars. All that other information just passes by. And what we're doing when we're doing the jury research is just like in the case with the kidney cancer case, we're looking at what those life experiences are. What are the filters that are filtering out the information that's good for our case, or filtering out the information that's good for the other case, and how we can use that information in coming up with our trial strategy. Now, I'm going to go back and show you that picture. You saw it really quickly. I'm going to show it to you again. And I want you to write down, if you have a pencil and paper with you, what is it you see? All right. Everybody ready? Let's go back and look at that picture. Now, some of you look at this picture, and I didn't do this picture. I didn't create this picture. This is a long-held study that was done many, many years ago, just looking at perception. Some of you look at this picture and you see a nose, and you see an eye, and you see the ears of a bunny. You're the bunny people. Something about your life experiences, your attitudes, your opinions, your belief. Maybe you had a small bunny as a child. Maybe you love Peter Rabbit. Whatever it is, when you look at this picture, you see a bunny. For others, you see a bird. You see the beak, you see the eyes, you see the back of the head. And again, something about your life experience. When you see this picture, you're prone to see a bird. This is a basic example of how jurors witness your case. And let's call the bunny the defense case and the bird the plaintiff case. They're going to hear the same case information, the same facts and information, but they're going to draw different conclusions about what they see based on those life experiences. And when we're doing this research, that's what we're trying to understand. What is it about them makes them see the plaintiff's case when they hear the facts? And what is it about them that helps them see the defense case? So jury research helps reveal all these processes. Real quickly, I'll do a super quick overview. So we're all kind of talking from the same page. Focus groups are exploratory research. They're generally done early in the case, Typically, they're done with a small group of 10 to 14 people sitting around a conference table. Generally, the rule of thumb is we want them talking more than we are. The goal is to give them information about the case and have them tell us what they think is important, tell us the information they want to know, tell us how we can best work up this case. Now, once you've gone through that process, you've gone through the discovery process, you pretty much know what your case and the other side's case is going to be, and then you're going to do more confirmatory research, and that would be a mock trial. That's where you typically get anywhere from 24 to 36 to 48 people together. You have a plaintiff and a defense presentation. You ask a lot of survey questions before, during, and after the people see the presentations. Then you break them into groups. You have the groups deliberate based on the verdict form. And then afterwards, if you have time, you can ask them a bunch of questions. What you're doing here is you're testing the case. You're seeing what works and what doesn't work. You can sometimes have to totally retool your case after doing that, which is why you want to do the mock trial with enough time to do another one if that's the case. But again, what you're doing at this point is you're basically testing the effectiveness of the case you think is going to go to trial. And then we do jury attitude surveys, and jury attitude surveys are done, and they're more like a microscope looking at a question. And so if you've seen all of these political polls that are done, that's a jury attitude survey, usually asking a very specific question. And typically what you can do is you can give a scenario of a case. And then you can, because you're using large samples, usually at least 100 to 150 people, if there are demographic differences in funding for the plaintiff or the defense, you have a level of confidence that those demographic attributes, if they are there, can be predictive. And usually they can be used in conjunction with the attitudinal information you come up with during research. They can also be done to maybe test alternative ways of defending a case, or a plaintiff can test, how much is too much to ask for in damages. But traditional research is not possible at this time. So what is it that we have as an option? Well, what we can do now is we can do remote online jury research. And like I said, this isn't new to us. We've been doing this for 6 years. But what is it? Well, what we found is that it's because of our best practices. It's secure. That in the 6 years of doing this, we've not had one security breach in the hundreds and hundreds of these online research projects we've done. It has proven value because, as it turns out, it's way cheaper to do. And I'll get into that in a little bit. And again, like you said, we've had 6 years of usage, and we know that it works. Now, comparing apples to apples, is it the same? So when we started doing this, we wanted to make sure before we started wheeling this out to our clients, that if we did an online project, we were going to get the same results as we did in an in-person project. So we did 12 cases. So we took 12 cases where we had done in-person research, and we did an online version of it. And we found that in those 12 cases, we were hearing the same things from our online participants as we were hearing from our in-person participants. We're getting the same findings. And then we did the same thing with our Case Explorer online research tool. We did it with the phone-in method, which was the standard at the time, and then we did it with the online method. And again, we were getting almost equivocal, exact results from doing it both ways. Since then, we've done it over 600 times before the pandemic happened, and the marketplace started speaking. We had a lot of consumers who use us, who are very sophisticated, people doing research, who do a lot of research for their cases, and they started exclusively doing the online jury research even before the pandemic, because they found it to be just as good, it was more convenient for them, and it saved them money, all of which I'll talk more about. For us, our product is Jury Live, and that's our mock trials and focus groups, and Case Explorer is our online research tool. So how do we do these Jury Live projects? We get surrogate jurors and recruit them. The key is we recruit them just like we do in the in-person one, which is we look at the demographics of the venue where it's going to be done. We have the panel of people match what the demographics look for in this community. We pre-screen them to make sure they don't know anybody or have any relationship to the parties in the case. We make sure that they're jury eligible. We draw from the sample size. We make sure that their demographics are similar to the demographics of the area. And that's the key. You got to have, if you start out with people that aren't representative, it's garbage in and it's garbage out. So, whether you do research with us or anybody else, this should be the first question you ask somebody: where do you get your people? They're trained, monitored, and secured. So it's really important that the remote online participants are screened and trained in advance of the project. And the reason for that is that on the day of the show, you want to make sure that everybody's internet connection works, that everybody, their computer can handle the platform. You want to make sure that they know how to use the platform. You want to work all this stuff out in advance so that the research project goes smooth. So that's number one. Number two, you need to have protocols in place to keep the project secure. And I'm going to go into more detail about that in a second, but you got to make sure that nobody is going to make their way into the research room until they go through several layers of security to make sure they are who they are and they're the people that need to be there. And then you want to make sure that they're monitored during the research project. And why is that? Me as the moderator, I'm doing my job and I'm focusing on these people. And I got a screen in front of me with 12 or 20 people in front of me. And so when they're talking, I'm giving them my attention. I can't be looking at everybody else while that's going on. And so the same techs that are training these people, that are checking these people in, they're also monitoring the project. So if they notice if somebody's having trouble, they'll call them offline and help them fix it. If they're not paying attention, not following the rules, they're going to deal with that. And that is really important so that something isn't going on over here that I'm not seeing because I'm doing my job. So this is how the process works in our best practices. Jurors log into a virtual check-in room and their identity is verified. And again, the same techs that are checking these people in have already met them when they did the training 2 or 3 days before the project. So we're comparing that we're getting the same people showing up who are supposed to be there. So once they do that check-in process, we send them to a virtual waiting room. And in that waiting room, we do pre-stimulus surveys. It's kind of like doing voir dire before the project. We want to see what the lay of the land is on their attitudes before they hear anything. And also that information can be useful for possible aid in jury selection if we find we get enough data and we run the stats and we see that certain types of demographics or attitudes are predictive of outcome. And we also do a warm up with them, kind of go over basically what the day is going to be like and kind of get them, revved up for the show. Only after they go through that process are they let in the virtual research room. And again, we've done this for over 6 years, and this process has kept all of our projects secure. And again, whoever you go through, and you're going to do research online, ask them what their safety protocols are to protect your case. Now, once we go through and do, let's say, a mock trial, and everybody gets together, they hear all the same information, and now we want to deliberate. Well, next what we do is we send them into separate breakout rooms. And each breakout room will have a professional like myself who will monitor and moderate the group, and they're separate from each other and they don't know what each other's doing. So how are these things conducted and put together? Generally, attorneys prepare summary presentations for a plaintiff and defense case. Now you can also, and I did one a couple of weeks ago, you can do a traditional focus group where everybody kind of gets prepared for the case, you get documents and things you want to show the people, and then you sit down and you just do a focus group. And so we did that, and the attorney and I did it. The attorney gave them a PowerPoint slideshow, we had a conversation, And it was just like doing a regular in-person focus group. This attorney who had been doing, their firm had been doing research with me for over a decade, afterwards said, Stu, you know, I'm never going to do an in-person project again. Why would I? In that case, they were in Georgia, I'm in Kentucky, the project was in West Virginia, and they got to do it at home. They didn't have to do the travel. Even if there wasn't a pandemic, they didn't have to burn 2 days of their life going to a project and coming back. But we oftentimes, especially if we're doing a mock trial, we're going to have the attorneys prepare presentations, both plaintiff and defense, in advance. You can do that these days with a simple cell phone. You can get more expensive equipment if you want. But again, we've had people do it with a cell phone. We've even recorded them in Zoom, doing it that way. But you get that recorded. We get that recording. You can have that edited, or if you want, you can pay us and we'll edit that for you. And so what we do is once we get that, I keep a copy of it. My tech who's going to be playing it has a copy of it. One of my colleagues will have a copy of it. And so if anybody's internet goes down, the next one picks up the torch, and we keep playing that presentation and keep going. And then again, as I said, they can also be presented live, and that is really the preference of the attorney and what they want to do and what they're comfortable. So like in person, on your left, you have an in-person presentation, a person standing in front of a group of people and giving their presentation. On the right, we have an online version, exactly the same thing. You have the presenter. In this case, he's standing next to a monitor, possibly showing a PowerPoint presentation or video. What the people are seeing is identical what they would see in an in-person project. The experience for the people is the same because the jurors hear and see the exact same thing. On the right, you have the jurors sitting next to each other, presentation. On the right, exactly the same thing. All the people can see each other, they can hear each other, they have the same experience as they do in a real presentation. What's it like for the client? On the left, you have a traditional mock trial where you have a one-way mirror and you've got the clients inside watching the deliberations or the presentation. On the right, you have the remote version. And what I'm hearing from clients is they actually feel like they're seeing and hearing it better. And here's why. You know, if you're sitting on the left in this classic research facility paradigm, you know, the person is maybe 10, 12, 15, 16 feet away from you, you know, possibly looking the other way. When you do it online, the person is right there. You can hit speaker view where they're filling up your entire screen, and you can actually hear them and see them better than you could if it were online. The trial team, depending on what's going on with social distancing where you live, they can either gather as a group in a conference room and watch it together, or they can watch it from home safely on their computer, having the same experience. And the way we do it is for the clients, we mute them and we turn off their cameras, and the participants don't even know they're in the room being watched by them. Like in person, we do frequent opinion measurements. So again, we do those questions before the presentation starts. We give all the same type of surveys we give during and after the presentations. Because of our Case Explorer platform, we can ask the same and give the same type of surveys that we do in live projects. And some of them are even better in terms of how our jurors input the information. So actually, I found that I can ask questions more effectively doing it in the online context than I could with paper and pencil surveys. And the other thing is you get the data back immediately, and where before it might take me 2 or 3 days to have a team of people entering this data, sometimes that very night I have the data and I can get it to the client, even with the open-ended surveys, because everybody's typing in this information live. Like in person at mock trial, there are full deliberations and discussion sessions. And we have really mastered this. It is amazing, and it really makes sense because think about it. Where would a person be more comfortable opening up and talking? Would it be in front of a group of strangers in a hotel room, or would it be sitting home in the safety of their home on a computer screen? Especially with, probably anybody under 45, where this is the norm most of their life, is sitting in front of a computer screen, talking, interacting with people. And so we have found that the deliberations are just as full, just as lively, just as informative as the in-person. It's become the new normal in ways it's better. It's got built-in social distancing, and it's got lower and fixed cost. The way we do it, it's a fixed price and everything is included. Now that's what we did for our in-person, but for the in-person, it's a fixed price plus expenses, because the expenses can vary widely on where you're doing it, when you're doing it, et cetera. So when you do it online, you're not having to pay for a facility, which can cost several $1,000s. You're not having to pay for a video team. You're not having to pay to feed the people. You're not having to pay to fly the research team in the hotels and rent a car. You're not having to pay for the travel expenses of the attorneys. You're not having to pay for the attorney's time. You're not having, if you're the attorney, you're not losing that productivity time with all the travel going to and from. When you add that up, the price difference is huge for doing it versus the online versus in person. And it also frees up when you can do it. Before it was always such a headache doing it in person, finding a time that lined up with everybody's schedule. This time it's way easier to do because you're not having to find, 2 or 3 day block of time for somebody. You're just having to find a 1 day block of time. And even if we record everything, so even if you can't make it that day, you can watch the recording at your leisure. And if you really are busy, you can pay us and we'll create a highlight reel for you of all the really important things that you want to watch. So again, one of the things that is really attractive on top of everything else is that it's just way less expensive to do. We recruit the people the exact same way that we do that it's in person. The discussion sessions, what do they look like? Well, let me give you an example of one we have here.
So the first one I want to ask you about, and this will be kind of a discussion with all of you, we'll do this probably for about 5 minutes, is have you or someone close to you had a recent or significant experience with a job termination, layoff, any kind of termination, and maybe it's related to the COVID-19 closures that are happening, but any experience with that, with a recent termination? And you can just raise your hand and Val will unmute you. Karen, yes. I'll get over to you, Richard. I'll get to everybody, so no worries.
Yeah, a friend of mine works in banquets, and he's out of a job now. There's no banquets.
Okay, all right. So that's pretty recent, is that correct?
Yeah.
So you can see the conversation is the same. And again, as the viewer, you can pick the Brady Bunch mode, which is what we're looking at now, or you can pick speaker mode. And I'll show you an example of what speaker mode looks like in a second, and just how crisp and clear the participant is, how you can see their body language, etc. Now, this is an example of what the presentation looks like, and you can do it many different ways, but notice there's 2 different ways this presenter shows the information to the jury.
Maybe she has another break or another fracture of the device that's in her leg. Eventually, on May 30th, 2017, Mrs. Lyons had another hip surgery. This one was performed by Dr. Liu at the University of Chicago. In this surgery, a different device is implanted. This device is called a claw device. The purpose of this claw device is to hold these moving pieces in her leg together in hopes that if they're firmly enough together, the bone will heal itself.
And so what this speaker did, he used 2 forms and methods of showing information to the jury. He started out having a screen next to him. And so whatever he put on the screen, the participants could see. And then he integrated into the video that he shot in advance the example of the X-ray. And so again, if you're pre-recording this, you have that option to where you can show them information multiple different ways in the way you create your presentation. And again, we talked about measurements. They're done exactly the same way and actually even better. So this is an example of using the speaker view and how well you can hear and see the participant sharing her opinions on the topic.
I just kind of figured 30 million was a lot. I feel like, you know, even though PSI, that they do deserve money, I feel like they, you know, maybe played a little part in things as well. I just felt like 30 million was way too much. And I always feel like with cases like this, they aim real high because they're going to bargain and go back and forth too. So I just kind of felt like 30 million was just a lot.
So again, you see this person is as clear or clear. You can hear her great. You know, everything that is as good or superior to what happens when you're doing online jury research or in-person jury research. The written reports that we do are the same. Again, it just depends on what your wants and needs are. We personalize the reports to what you want us to give you, but they're the same as we do with an in-person project. And so just in summary, before Diana shares with you about how to develop graphics and using the online jury research or regular research, you know, the keys are, from our experience doing this 6 years, the pandemic has forced us into having this be the only option. You know, but what I don't want you to think is that you're being forced into something that what you were getting before. Because from our experience, it's as good or better if you were doing research before or thought about doing it before as it is now. And so that's the really good news about this. But key things to think about when you're going to do it. You know, whoever you choose, you know, talk with them about the security measures. Talk with them about how they get their people. Talk with them about what they do to ensure that those people, when the project happens, are going to know what to do and it doesn't, you know, turn into a train wreck with everybody dropping off and having problems. You know, talk with them about, you know, how it is that you're going to do these presentations in a way that are going to be effective for the audience. And I think if you go through those and you follow those best practices that I've talked about today, you're going to have a really good experience doing the online jury research. It's going to save you money. And I think you're going to get the same information you would if you had done it in person. And so now I'm going to pass the ball to Diana. And Diana and I have worked together for over 20 years. She's, in my opinion, one of the best in the field at doing strategic graphics. And we've had a really good relationship because she works with me when I'm doing the research. And we just had a case a couple of weeks ago where Diana sat in on the research. We developed graphics in advance of the research. And while we were doing the research project, we were testing those graphics, finding out what we could do to make them better, and then talking to jurors about graphics they want to have to help us be more effective. And Diana was great in taking that information and utilizing it to create new and better and more effective graphics. So with that, Diana, I turn it over to you.
Thank you, Stu. Hello, everyone. Can you see my screen right now?
Yes, I can.
Great. Okay, what I'd like to do today is just share with you in these few remaining minutes the value of using demonstratives in a jury research exercise and how doing so can improve the demonstratives that you use at trial. So let's take a look. So what are the benefits of using demonstratives in research? Given the time constraints of any sort of research project, using a few well-planned graphics will help you tell your story very quickly. It'll crystallize what each party's view of the case is. It will reinforce what you're telling them verbally, and then provide that information for them to take into the jury room for deliberations. And that's really what you want to learn anyway. So it's, and in addition to this, you also, as Stu mentioned, get the feedback from jurors in terms of what worked for them, what they understood about the graphic. It will lead you to decisions on your themes and how you might tweak the graphics as you move forward to trial. And so what I'd like to do now is give you an example of a graphic that was used in research. So what you see here is the demonstrative, well, actually, it's the image that was provided to us by the attorneys to explain this very complicated process. There were a convoluted series of transactions in which a bank provided funding to a municipal entity called the CCTA, as you'll see here. So the CCTA eventually passed all of the funds back to the bank very quickly. So there was no risk to the bank. And that's a key point that we needed to present to jurors and get them to understand. So we, as you can tell from this diagram, we had our work cut out for us in terms of developing demonstratives that were clear and understandable. So what we did, as we learned more about how the transactions worked, we realized it was just one big loop, and we wanted to show that to jurors. So we used an image in the bottom half of the slide, text describing each of the points in the top half of the slide, and we began with anchor investments, and you'll see we end with anchor investments as well. So in the research exercise, after deliberations, we often ask some very general debriefing questions about the demonstratives. And one question we asked in this particular case was, what were the good points in the defense presentation? And what you see, the bullet points you see are all directly from the mock jurors. And you'll see they retained this, they got it, they understood. Everything was a loop. There was no risk to the banks. There were payment circles and the money just went in circles. And this is exactly what we were trying to convey to jurors. So this, we made a few modifications. This general loop structure was used in opening. It was used in much more detail and with supporting documents with the expert witness. And it was used again in closing, and it was a very favorable outcome for our client. So as we talk through different exhibits and how we create them, I'd like to just quickly share with you a few examples of what we call before and afters. The before is what the data we receive from our clients, and the after is what we've created as a concept to be used at trial. And this is a way for you to see our thought processes and also consider ways that you may look at simple information and make it more interesting and compelling for jurors. So we start out with this simple list of the board of directors and what their responsibilities are and to whom. And you'll see it's a very simple list of the key constituents. The shareholders were the most important in this case, but you see they're stuck at the bottom of the list. So what we created instead, we used this visual anchor of an umbrella image because it indicated a more protective role of the board of directors. And then because the shareholders were really what was most important in this case, we used an image that had color so it would draw the eye more to that particular constituent. Now, as we know, timelines are very helpful. And we'll discuss those in more detail in a little bit. Here on this one, this is well laid out. It explains the critical dates and the proper sequence. But as we were talking with the attorneys and discussing the case, what we learned that it was more important to show where Sam Johnson lived than the dates of the moves. And so we created this map which shows each location revealed in chronological order, so you can see where Sam lived in the world at the time of the seizure and then after the seizure. So that date became very important, but seeing that he lived in various parts of the world was as compelling, okay? And then finally, this was used in defense of a product liability matter. And here, we needed to show how many medications the plaintiff was taking in addition to the drug at issue. And it was a very long list, but it was not very compelling. So we created this medicine cabinet look. We listed each of the names of the drugs, indicated which ones could cause liver damage as well, in fact, all of them. And it was a much more graphic way of showing all the medications that the plaintiff had taken at the same time as taking the drug at issue. Okay, so now I'd like to show you some samples of demonstratives that were used in trial and talk to you a little bit about how using these more unusual pieces can be a little bit, can be more compelling and memorable for jurors. So generally, when we tell a story, we do so in chronological order. We know it's easier to remember events if they're on a timeline. And so generally, you always see a timeline in a case, right? So this was created for an opening statement. And you may be wondering why I'm showing you only 2 entries, and that is purposeful. When we created this, we needed to be able to show that the reinsurers were required to reimburse the primary insurer within 48 hours of settling the claim. That did not happen in this case, although it was required by the contract. So what did happen? 13 years later, the claim was still not paid. Now, this was the intro that we used in opening, and it was very effective because we showed the long span of time unfolding. This is a great way of explaining what this case is about. Now, of course, during the rest of trial, as experts and as fact witnesses mostly came in, we were able to fill in this timeline. But that sense of a lot of open space and no payment being made for 13 years was compelling. Again, with timelines, you may have done this already. This one compares what Lex Tower told the landowners versus what it told its investors. So conflicting statements, conflicting intents. And of course, with these doc icons, these little icons here, you can click on these. They're linked to document excerpts and explain what, see the actual documents and see the actual excerpts of the documents. And that's very helpful for jurors. If you provide the entry, then go to the document that supports that entry and then back to the timeline. It provides a very clear sense of verification. So you're verifying what you're telling jurors. We know from research exercises that jurors often want to see the documents, and this is a way to do that as you're building the story and letting that unfold, okay? Now, oops, technical difficulties. Okay, so what I'd like to do is show you just a couple of animations. This first one really explains one of our basic tenets of developing graphics for complex matters. And that is, when we do so, we want to always begin at a known point, something that's understandable for jurors. Here, this was a patent matter. We needed to explain the inner workings of a cell phone. So we start by showing the back of the Samsung phone. We remove the cover and explode the pieces. And so this view was one jurors would see repeatedly, because once we did this, we would zoom into a particular component, fade everything else back so you could only see this component. Then as we explained what it was used for, what the patent language was that covered that particular piece, we could provide that information on the side, the text, show the patent language, etc. Then we would come back to this full view and then choose another element that we would highlight, fade everything else back, and discuss that element. And by being able to see this particular view multiple times, jurors became more familiar with how, although they may not be able to tell you exactly how a phone worked or what the pieces were, there was that sense that, oh, I know what that L-shaped piece is compared to the motherboard. So those are the types of things that we just wanted to get them familiar and able to move into different layers of complexity by starting at a known element, okay? Here's another animation, much different. This is a reconstruction, obviously. What's important here is we end the animation where you can see all of the key factors. The red light that the truck sped through, the skid marks he left, this car who had the green light and was starting to emerge into the intersection. So this is another example of animations. Now, the last example I want to show you is something we used in closing. And this was a case involving a robocall. And we know robocalling is illegal if it's not for a political ad. So the plaintiffs in this case were on a do not call list, but they received a robocall on their answering machine in error by this marketing company. So the plaintiff sued the marketing company, and with all the penalties and all the damages, demand was just skyrocketed. So we were working for the defense, and the attorney in his closing started this graphic and he was silent for 10 seconds. So plaintiffs here were demanding $162 million per second. And I'm happy to say the jury found for the defense and found that to be too much of a windfall for plaintiffs. So as my final point today, I'd like to share with you a quote from a judge who served as an arbitrator in a mock arbitration exercise that we conducted. And his point about demonstratives was, I'm very big on treating an arbitrator or judge as a jury. Very important. Do not assume the arbitrator or judge gets it. Say it and show it. So Stu and I are happy to take your questions at this time. This concludes our presentation. Have we any questions? Brian?
I have a few through the chat feature, and if anyone else has questions, please enter them into the chat and I'll pass them along. What is the timing of graphics and research? And I think that they're referring to how long it takes to conduct it.
Diana, you want to go first and then I'll follow you?
Sure, thanks, Stu. So timing for demonstratives very much depends upon the size of your case, what you're looking to do, the complexity of the matter. And, you know, ideally, we would like several weeks in advance. For very long, complicated matters, 8 to 10 weeks is really helpful. However, we've also done the couple of small demonstratives for a hearing or for a short trial with a week's notice. So just bear in mind that the more time you provide, the more thoughtful we can be about developing demonstratives and work with you to refine them based on what we learn about the case, how you react to the design work. Okay.
And the
Stu?
research, the research is very similar. The sooner you do it, the more you can do with the information. And talking about doing a focus group, I can't tell you how many times somebody's brought me into a case kind of midway through discovery, and we did a focus group and we learned all kinds of great stuff, but they were kicking themselves because they wish they had had that information for those 6 depositions they'd already taken. And so you can do it at any time. And, oftentimes people get busy and what have you, and they call us in at the 11th hour. We can absolutely come in and do a focus group or a mock trial for you on short notice. But if you can be a little more proactive when you get the case and just look at, what are the issues and questions you have and get us to engage earlier, you just get more bang for your buck for doing that. Generally with a mock trial, as I said, the timing for discovery is done. You've at least got the expert disclosures and you know where the ground is for both sides of the case. At that point, I wouldn't, if you have a choice, I would do it no later than 6 or 8 weeks before trial. So to give yourself time, if it turns out you found a really, really bad problem and you had to retool everything, and I've had this happen, it gives you the time to do that follow-up project to make sure the retooling is actually going to be effective.
Thank you. And I have one other. How do you decide what type of research project to conduct on a case?
When we first get consulted with somebody or we first meet them, we have a very long conversation with them about what their needs are in the case, what their concerns are about the case. We look at where we are in discovery, and all of that helps inform whether you're doing more of an exploratory project or a confirmatory project. Obviously, if it's very early, it's clearly going to be a focus group. You're going to be, gathering information from jurors. You're going to be help crafting strategy. When you're kind of midway or 3/4 of the way through, then you can still do the focus groups, and they can be very effective. And then once you're kind of crossing that threshold where you really know all the facts of the case, that's where you're clearly in doing the confirmatory research, the mock trials, or doing the community attitude surveys. And again, the community attitude surveys can be done at any stage along the process because they can have different goals along the way.
Thank you. Those are the 2 that I have. If anyone has any other questions, please feel free to enter them in the chat or reach out to me. I'm happy to put you in touch with Stuart or Diana.
Yeah, and if you guys wake up at 2 in the morning and you have a question about what we talked about today, give Brian a call, send him an email, and Diana and I would be more than happy to answer that question for you. We're here for you in that realm.
Well, thank you all for attending.
All right, everybody be safe.
Thank you. Bye.